Assuming you've already acquired a franchise, something else you want to consider is, what do you do when disputes arise? The first thing you want to look at is what the nature of the dispute is. In franchising, there are some reasonably commonplace disputes. Some of them concern the area of wrongful termination, where a franchisor will terminate a franchisee for whatever reason, usually for non-payment, but sometimes for others depending upon what they're allowed to terminate a franchisee for in their agreement. Another commonplace dispute is called encroachment, where a franchisee has a specifically delineated territory and the franchisor, either knowingly or unwittingly, allows another franchisee to operate within the first franchisee's exclusive territory. A third area that comes up frequently in franchise disputes is fraud in the original offering document. Sometimes a franchisor will make promises or make claims in their franchise disclosure document that prove to be untrue. In these contexts, a franchisee can sue the franchisor, but it depends on what the particular franchise agreement says as to what forum the franchisee can sue in. Now, from my experience over the past few years, many franchisors are requiring franchisees to engage in mediation before they can actually litigate the dispute. Many more require that rather than having the ability to go to court, a franchisee must bring their claims in arbitration. Now, this is claimed to be quicker and cheaper, but again, from my experience, it has proven to be just as expensive as regular litigation and is much closer to a trial by ambush because it doesn't have any of the pre-dispute disclosure obligations that a normal litigation would have. In an arbitration, for example, you rarely get the right to take depositions, to give interrogatories that have to be answered, to use other litigation techniques that they deem unavailable in franchising. The third forum obviously available to franchisees is litigation is to go to court. Now, when a franchisee is forced into this dispute resolution mechanism, one of the claims that has to be made is a claim for damages. The most frequent claims that franchisees make for damages are things like lost profits, loss of business value. Frequently they will complain that the franchisor's behavior is so egregious that they are also entitled to punitive damages. Now, all of these calculations are usually such that they require expert testimony because courts do not simply allow a franchisee to make a claim because they throw it out claiming it's too speculative. So in order to provide the certainty, the law generally requires that complaining franchisees make their damages claim by use of expert testimony.